Hi, this is Stuart Weems and welcome to the Investopoly podcast. My goal is to give you simple, easy to understand strategies, insights and tips to help you master the game of building wealth. And in this episode, I'd like to talk about wills and estate planning documents and how to set them up properly and some sort of tips and tricks around making sure that they're adequate. Now, I would say probably at least 80-90% of new prospective clients that I meet won't have up-to-date wills. Most won't have wills at all, and if they do, they tend to be out of date. You know, they're prepared 20 years ago or so forth before they had children, and therefore aren't current. And I guess that, we all hope that it's not an urgent task, but I guess we also all acknowledge that it's an important task. And I think probably the thing that prevents people from getting it done, apart from the fact that they hope it's not urgent or they're planning on it not being urgent, is they just don't know where to start. It seems quite complex and they don't know who to get advice from and so forth. And so what I hope to do in this podcast is kind of uncover some of those uncertainties and hopefully demonstrate, in the main, I would say probably for 90% of people, ensuring you've got current wills and power of attorneys and so forth is actually a pretty simple task, pretty simple and easy task to do. The first thing to talk about is that the laws that govern the administration of wills and intestacy are state-based. So it depends on your jurisdiction, your state that you're residing in, about what will apply. But typically, if you die without a will, it's called dying intestate, and it can have many adverse consequences, including your assets being distributed to people that you wouldn't otherwise agree with, and certainly creates a significant amount of unnecessary work and complexity for surviving family members at a time when they probably need more simplicity than complexity. If your situation is very simple, then I would argue that you just need a very simple will. And simplicity really means that you don't have much in the way of any significant assets. You don't have any specific beneficiaries or financial dependents, such as children or a spouse. And in that sort of situation, I reckon a template will that you can buy online would probably do the job. And they tend to be pretty cheap, around about $200. Just make sure your will is witnessed correctly. That's the key thing, to make sure the will is valid. It's okay to draft a 2-page will that's pretty basic if your situation is basic, but if it's not witnessed correctly, it's not going to be a valid will. Of course, if you have, and by the way, I've got a link in the blog and obviously on the show notes as well, to a company called ClearDocs. They prepare legal documents. They sell a will for about $200. That's where I would go if I was looking for a pretty simple online version. Now, of course, if you have more assets or financial dependence and so forth, your situation becomes a little more complex. And in that situation, I would always counsel clients and people to seek personalised legal advice. Now, you don't necessarily want to invite more complexity than your situation warrants, of course, but you don't know what you don't know. And that's when you should go and get personalised advice. And that advice might be, no, it's okay, you just need a really simple will. Or, hey, there's a few things we need to think about or consider. Of course, having kids complicates matters. Not only do you need to potentially provide for their care if you and your spouse pass away, and when I talk about spouse, I'm obviously talking about married couples, same-sex, de facto, really lifelong partners and so forth. So if you and your spouse pass away at the same time or relatively close together, and your children are under the age of 18 or perhaps even 21, as I said, you'll need to provide for their care from a financially perspective, but also you need to provide for their guardianship. And so you need to nominate someone or peoples in your will that's going to become your children's legal guardian in the event of you both passing. I would also typically advise clients to consider including a testamentary trust in their will. I've got a link in the show notes in the blog, of course, to what a testamentary trust means. But essentially, it's a special discretionary trust that's created upon death, and it allows your executor to potentially move your assets inside that trust. And it has some asset protection, but also taxation benefits, namely that a testamentary trust can distribute to people under the age of 18, that is your children or even grandchildren, depending on your age and stage of life, and they're taxed at adult tax rates, which means that they can receive, circa $20,000 a year without paying any tax. So very tax-effective structures. Now, another thing that creates even more complexity is blended families. And a blended family is one where both spouses have children from a previous marriage, or even just one spouse has children from a previous marriage or relationship. And those sorts of arrangements can create a myriad of potential risks and issues and planning opportunities and so forth. And so anyone with a blended family, I would almost certainly, absolutely recommend they go and get personalised legal advice. The third category of sort of complexity, if you like, is beneficiaries with special needs. So if you have a beneficiary, which might be a child, a grandchild, whoever it is, even it could be a sibling, for example, and they have a disability or they're battling an addiction, mental health, or these sort of similar sort of issues that may or may not have capacity to make their own decisions, may or may not have capacity to look after themselves. Very important, again, that you go and seek personalised legal advice to ensure that you've set up your will in a way that's going to assist them. So how do you avoid problems after you pass? And look, you might think, oh, well, I don't really care what happens after I die. It's not really going to impact me. But the thing is that money and grief tend to not really mix very well. And we've seen, I've seen lots of otherwise very healthy family relationships turn sour when money becomes involved. And people start bringing up things from their childhood that may have occurred, some 50 years ago when it comes to separation or split of assets. And so you can make it a very simple and easy and conflict-free process, or you can make it really difficult, and obviously not preparing a will or organising your affairs tends to make it difficult. Just a few tips in order to avoid any complexities or infighting and so forth, conflict, I should say. The first one is just have difficult conversations while you're still alive. If you plan to distribute your asset base unevenly, if you think the distribution of your asset base could potentially cause conflict, if you are purposely going to leave someone out of your will that might otherwise expect to be included, those sorts of situations, you're much better to have those conversations while you're around. Make sure everyone knows that's your intention, at least the person that might create the conflict at least. And then there's not going to be any surprises. Whereas if on the day that your will gets read, if it's going to cause any surprises, that tends to invite more conflict. The second strategy is to use offset clauses in your will. And so an offset clause would come into play to equalise the distribution of your estate amongst your beneficiaries. So let's say you had two children. Your aim or goal or desire was to distribute your assets evenly to those two children. However, because of circumstances, you've provided, early inheritance, financial support, additional gifts and so forth before you pass, but you've only provided that to one child. You can put an offset clause in your will to make sure that your executor equalises the distribution. So takes into account the fact that one party's already received a certain amount of financial support. So on distribution of remaining assets, the party that didn't get any support while you're alive is fairly compensated for that. So you need to have an offset clause in your will, and then you need to keep good quality, easily accessible, easy to understand records, recording the financial support that you actually have provided some of your beneficiaries while you've been around. The third strategy is to keep assets out of your estate. So your will typically covers assets that are in your personal name. The assets that aren't included in your will or covered by your will are any assets held in a discretionary family trust that the beneficiary isn't what's called presently entitled to, so the trustee hasn't made any election. The second is superannuation. Superannuation falls outside your will. And the third is any jointly owned assets with other parties, such as people tend to own their family home in joint names. And what happens when a joint owner passes away, the ownership automatically passes to the surviving joint owners, so that doesn't even really hit their will. So if you can put all your assets inside a trust, inside super, and any property assets you own jointly, then you're not going to have any assets in your estate, and no one can fight over zero, or at least there's less incentive to fight over zero. The fourth tip to avoiding conflict is make gifts while you're alive. So not only is it likely to avoid conflict after you pass, but I guess there's two other benefits. Is that the beneficiaries receive their money sooner, and typically that's better. I mean, people would prefer to receive an inheritance when they've got a large mortgage and young children and big expenses and so forth than when they've already financially established themselves. And secondly, you get to enjoy the positive outcomes that these gifts create. So gifting monies, early inheritances and so forth are meaningful. As I said, super falls outside of your estate, and essentially the trustee of your super fund must decide where to pay your super. These days, almost all funds now allow what's called a binding death benefit nomination, which means you nominate who your super balance should be paid to, and the binding feature or nature of that nomination is that the trustee has to follow it. Typically, those nominations have to be updated every 3 years, so that's really important that you do that. You've got a few options in terms of who you can nominate. You can nominate spouse, children, an interdependent relationship. That's essentially a relationship where you're providing financial or domestic support. So it could be a niece or nephew, for example, that you're looking after because their parents aren't able or willing to. And lastly, your estate. So they're really your four options. In most circumstances, I would advise people to nominate a financial beneficiary, so that is a spouse and or children, as this will ensure the benefit payment is not taxed. So money that comes out of super that goes to a financial dependent will be tax-free. So sorting out your own affairs is certainly one step, but it's also important, although somewhat sometimes uncomfortable, to consider what steps you can take if you expect to receive inheritance in the future. So if one of my clients was to expect to receive an inheritance, my preference would be that they would receive that via a testamentary trust. And the reason, as I've previously spoken about, is not only is it better for asset protection, but a testamentary trust can distribute income and capital gains to a minor. And normally minors are taxed at different tax rates, much higher tax rates than adults. But in this situation, if they receive a distribution from a testamentary trust, they're taxed at adult tax rates, which means that they can receive about $20,000 a year and not pay any tax. And obviously, if they receive more than $20,000, say 30, they're still not going to pay very much tax at all. So very, very, very tax effective. So if one of my clients was to receive inheritance, that's the way I'd like it to be received. But the person that provides, the testator, they call it, the person that provides the inheritance or makes the gift, which is typically your parents, must include a testamentary trust in their will. And so it can be a difficult subject to talk about or bring up, but something to keep in mind, particularly if your parents are open to that sort of conversation, to make sure their affairs are in order. And again, I guess following some of the tips that I've given you to avoid conflict, making sure your parents' affairs are in order might actually help you, not only you, but also any other family members as well. Typically, when drafting a will, I like to keep the will worded as wide as possible, and that means that your executor has enough flexibility in order to execute on your wishes. And so a good example might be, sometimes parents say, okay, well, we will distribute assets when the child attains the age of 21. But I know in my personal circumstances, if one of my sons had a gambling addiction or something along those lines, you wouldn't necessarily, certainly if I was around, I wouldn't want him to receive any inheritance at that time. So being too codified in your will can create perverse outcomes that you wouldn't otherwise be happy with. So a way to get around that is to leave your will worded as widely as possible. Now, you tend to have to nominate an age, but maybe it's a latter age. And then what you do is draft what's called a letter of wishes. And a letter of wishes is a non-binding document that really sets out the manner to which you hope your executor will exercise or implement your will. And that's a much better way, particularly if you've got a high level of trust with your executor and you think that they're competent in exercising your wishes, then essentially you leave them enough room to execute it correctly, to accommodate any known and unknown risks. And then in the letter of wishes, you can set out exactly how you'd like to be dealt with, in what circumstances you don't want them to distribute money, either money or assets, capital that is. And the benefit is you can update that letter of wishes at any time. So normally you would provide a copy to your executor and you would keep a copy in a safe place. And you can redraft it at any stage. You don't need a lawyer to do that. Of course, in addition to wills, you need power of attorneys. That's so people can make decisions and execute documents if you're not available or able to do so yourself. You need to have two types of power of attorneys. You need to have an enduring financial power of attorney and then a medical power of attorney so that people can make medical decisions on your behalf. You need to review these documents regularly, although I would say a well-drafted will and power of attorney can typically wouldn't need to be updated any more than every 5 to 10 years, but that's not to say you shouldn't consider them every 1 to 2 years just to make sure that they're still adequate and up to date. So there you go. There's some tips and tricks on how to set up a will. Keep it as simple as possible, but not too simple that you create unnecessary risks or problems or complexity later on. Quite often, if you've got children, special beneficiaries, or blended families, you need to get a lawyer to draft your will. If you have very simple circumstances, low assets, no dependents, and so forth, then typically a will kit should be sufficient if it's witnessed properly. And that's it for now. So until next week, bye for now.